Wasiyat is from the Arabic term wasiyah, mean moral exhortation or moral duty. According to Hidayah, wasiyat mean an endowment with the property of anything after death, as if one person should say to another, give this article of mine after my death to a particular person. Wasiyat also can be translated as an ikrar of a person made during his lifetime on his property or benefit to perfect something for the purpose of charity or any purpose permitted according to Islamic law after he died to non-heir and heirs who are protected from receiving the estate. A will is important because it covers of how a person's assets get distributed. Many drama have started because of family members fighting over an inheritance. Also, wasiyah can take quite some time for the asset to be distributed, up to 5 years. This may pose an issue if the person is the sole breadwinner of their family or have dependents. Furthermore, there's also the chance that the asset might depreciate in the time it takes for the person will to be executed. By having a will, family members will know how much the person has and where to find it. It will also save them a lot of headache from administering the person's estate and dealing with any complication that may arise from that. If the person passes away without a will, all of their assets will be distributed according to the Distribution Act 1958. The person wishes or needs of his or her family members will not be considered.
There are a few types of wills. The first types of wills are holographic wills. These wills are entirely handwritten and self-signed by the heirs. Then the will is kept by the notary. The notary is obligated to make a care act signed by the notary himself, the heir, and the witnesses. The description of the daycare act should be clarified at the bottom of the will. An holographic will has the same power as a will made with a general act. The heir can reclaim his holographic will at any time, and the return is evidenced by his own authentic act. The second will is a general will. A will with a general act made before a notary and two witnesses. A notary who writes the will himself or tells someone else to write the will of the heir. Further, the will is signed by the heir, notary and witnesses. The third will is a secret will, a will with a closed or secret act made and signed by the heir or the other person who is commanded by the heir. Then, the heir delivered the will in a closed state and sealed to the notary before four witnesses. In the submission, the heir shall explain that in the letter his will is listed and that the will was written by himself or by another person whom he has commanded, and he has signed the will. The notary will make an explanatory act and be signed by the heirs, notaries, and witnesses. Thank you.
The conclusion is, many of us consider a will to be insignificant. This is because the average view is that the division of the estate is limited to the heir and is divided through the fate method only. It should be understood, the jurist has agreed that a will to parent and a relative is obligatory for people who have property. It is based on the word of Allah Subhanahu wa Ta'ala, which means you are obligated when one of you is about to die. If he has left property, let him make a will for parents and relatives in a good way, according to religious rules, as an obligation upon the peers. Surah Al-Baqarah 180 word. Although testamentary law is an actually of consumption that is encouraged, but testamentary law can also change according to the situation. First situation is wajib. A will become obligatory when a person has responsibilities that need to be fulfilled, especially those in the form of right of God, such as zakat, kafarah, and haji, which are fear cannot be fulfilled, it is not bequeathed to someone to perform it. Similarly, responsibility related to human rights such as having property entrusted to him and unresolved debt. Next, sunat. If bequeathed to relatives in need while they are not entitled inheritance. So, also bequeathed to the poor and for the purpose of virtue in the way of God. Next, haram. A will become unlawful when a person bequeaths something that is forbidden by Islamic law or intended to harm the heirs. Harus. A will becomes a must if made to a wealthy person, either from relative or any party with no specific purpose, if the will is intended to do good and connect the cord of friendship. Then it becomes consumption. Lastly, makruh. A will become makruh if the testator has little property but at the same time has a poor heir who is in the need of property. Similarly, it is not appropriate to give a will a wicked person or a person who often commits immorality, because it is feared that giving a will further increase his tendency to commit immorality. Thank you.
My name is Rukaya binti Mustafa. My matric number is 061527. Pillars and conditions of will in Islam. First, the testator, al-musi, the rightful owner of perfect property at the time of deed, in a conscious, sane, will voluntarily and independently. 2. The testator, al-mushulahu, the beneficiary of a will is a general, example, an individual, charitable body. The testator must be clearly known except for matters of welfare, membership, and can receive property, not shares according to the opinion of Jumhur Fuqaha. 3. Property bequeath, which means al-mushubihi. Property consists of movable and immovable property. Halal utilized, transferable, can be owned by the testator. Property valued according to the Islamic law, and the property is not spent by debt, and the property rate does not exceed to the testator property. 4. The wording of the will, sigha. This is a transaction process of pronouncement of will, consent and acceptance, intention by the testator and accepted by the testator. This consent should be taken into account after the deed of the testator, regardless of whether the testator has already consented or rejected this will before the deed of the testator. 5. Ijab. It can be made through words, writing, or gesturing, clearing the meaning of a will and should continue until the testator dies. 6. The last one is acceptance. It can be made after deed, either explicitly, conversation, or dilala, through deed or silent. The denial of a will must also be made after the deed of the testator. Acceptance and rejection of the will is not required immediately, and the right to accept and reject it. A will passes to the heirs if the testator dies before doing so.
The executor's responsibility is to see that everything stated in your will is carried out as intended. Trace your will is one of his other obligations. Apply to the court for a probate grant, which entitles the recipient to control the deceased person's assets. List your positions, deal with your debts, make a will and distribute your property accordingly. Create an account statement when an executor assumes control of your assets. He or she also assumes responsibility for managing these assets as trustee for your heirs up until the distribution is finished. A trustee is still subject to responsibilities set out in the Trustee Act 1949. The executor is also entitled to asset management expenses at a reasonable rate and reason. According to the Wills Act in Malaysia, you can appoint up to 4 executors aged 18 and above to 8 as your trustees. You also have the right to nominate another person to replace any executors if they die early or relinquish their executors. The heir can also be an executor. For example, if you bequeath all the property to your spouse, his or her appointment as executor is a good option. But if you want to appoint someone as an executor, it is better to inform them and get their consent first. The executor refuse the responsibility of holding the trust because we was not too in advance. There is also another option, which is to appoint a trust company. The decision to appoint an executor is highly dependent on the amount of assets and the level of company.
Wasiat is declaration of a person made during his lifetime with respect to his property or benefit to be carried out for the other purpose of charity or for any other purpose permissible by Islamic law after his death. Next, we can write the will and how the will happen. A will goes into effect only upon will demise, and any person above 80 years old and can make a will. Next, the executor is the organization or person who will ensure the will wishes are being fulfilled to the will specification. Moreover, the executor is responsible for carrying out the whole process of the state administration. In addition, a well structure will ensure the interests of the heir are safeguarded, guaranteed, and preserved in a professional manner. A will allow you to appoint a trustworthy guardian to help to protect the welfare and interests of the children, especially minor and disabled after the demise.
I will talk about the cost of writing a will. The fee charge is 500 ringgit Malaysia for a basic will and 1,200 for a comprehensive will. Fees include the writing and keeping of all a will, regardless of the amount of asset in the will. Next is cancellation of will. The testator may cancel or withdraw his will at any time during his lifetime. However, when the testator has died, no revocation can be made because the will has come into force. Similarly, the heirs also have no power to cancel the will and or cancel the appointment of an executor in the will. Only a court order can revoke a will or the appointment of an executor if the will is disputed by any party. Okay, so also it's become an offenser if heirs deny that the testator has a will then when they know about the existence of the will. So the following are the provision of the Muslims' wills. Enactment 1999, amended 2016, Part 3, a revocation of will. Subsection 12, a will shall be void if the testator withdraw his will. Execution of will. Subsection 15, a will shall be deemed to be revoked if the testator commit an act or creates a circumstance which indicates by qarina or uruf that he has withdrawn his will. Subsection 16, a person should not be considered to have withdrawn his will due to denial of the will by another person. A complete will is valid during the life of the testator and will take effect when he or she dies. This means the appointed executor should execute the will and apply for the probate grant in the Civil High Court to confirm the appointment of the executor-in-law. However, the executor who has been appointed has the right and may use discretion to reject the appointment, renunciation, on reasonable ground. Subsection 8, Probate and Administration Act 1959. Any person who is or may become entitled to representation may expressly renounce his right to representations.